With Senator Patterson.
Thank you, Chair. I have some factual matters I want to go to in a minute, but I just want to start at a high level. What would the consequences be if this bill did not pass?
So, Senator, I think there are three fundamental things that this bill is doing. The first is to reflect in legislation the revised test that was established by regulation following the High Court's decision in YBFZ. And whilst that regulation is valid and in effect, we need to mirror that in the legislation. The bill assists us in removing impediments to removal. I've just made very clear that the cohort eligible for removal and the provisions around removal are not changed by this bill. This actually assists us to exercise our obligations under the Migration Act. And finally, it assists us in the management of the BVR cohort. And Ms Sharp can add some detail to this, but it clarifies provisions around our capacity to use spent convictions, and it allows us to reassess protection visa findings. This is all about enabling us to give effect to our obligation under the Migration Act to remove people who no longer have a right to stay in Australia. And as I said in my opening statement, the capacity to do that is critical to the effective management of a migration system.
But we have had some witnesses say that because the government has already issued regulations in response to the High Court's decision that allows electronic monitoring and curfews to be reimposed, that the bill is not necessary, and you've just said the regulation is valid and in effect. So what would the consequences for that regulation and the control of those people in the community be if this legislation does not pass?
Senator Claire Sharp, the regulation establishes the mechanism by which electronic monitoring and curfew can be imposed if the new community safety test is met. As some of the witnesses earlier referred to, Section 76E of the Migration Act allows a person who's had electronic monitoring or curfew or one of the other prescribed community safety conditions imposed to make representations to the Minister as to the reasons why they should not be imposed on them. If we don't make this Act amendment, what we've got is a reference in Section 76E to the old test, so it'll be sitting out of alignment with the regulations. That's, at best, from a legal point of view, very untidy, and at worst, I think, introduces uncertainty into the framework that we'd like to avoid. Uncertainty which would cause there to be questions about the validity of those ankle bracelets or curfews? I think having that misalignment could cause questions to be asked about what tests should the Minister apply at that second stage consideration. So, as I said, we very strongly believe the amendment to Section 76E should be made. So there is a risk, if this bill does not pass, and particularly if it doesn't pass properly before the Parliament rises for Christmas, that in the intervening period before the Parliament returns again next year, if the Parliament returns again next year before the election, which we don't know, that curfews or electronic monitoring that has been imposed by this regulation could again be found to be unlawful and people could be free in the community without restriction. I think the bigger risk is more to do with the minister. We want the Minister or their delegate to take decisions under Section 76E promptly and not to have that procedural fairness mechanism is a really important part of the system, and we would maintain that visas granted pursuant to the new regulation are valid, but we'd be very concerned about people not having access to the procedural fairness mechanism, applying the correct test as dictated by the High Court. Would you like to add anything to that?
I think, as Ms Sharp was saying, it is important to note it's the initial decision to impose that is made under the regulations. The alignment in 76E is a post-decision element where it is important, as soon as practicable, for that to be aligned so that the same test is applied on that second stage decision, the procedural fairness decision.
Yes, certainly understand why that's desirable, but what I'm trying to get you to clearly put on the public record, given that the government said that this bill is necessary for public safety and needs to pass swiftly, is what the adverse consequences for public safety would be if this bill does not pass.
Maybe I'll try again. As you are familiar with, this is a heavily litigated area.
Indeed.
I think we're very careful to ensure the Migration Act is very clear in the way it imposes requirements and duties and processes. And should we be faced with a situation where the test in the regulations and the test in the Act are out of alignment for a long period of time, I think there could be people, obviously not the Commonwealth, calling into question the effectiveness of the regime.
Legally calling into question.
Correct.
Yes.
Make challenging decisions and trying to... I don't want to, at the table, in any way sort of suggest any cause of action that I think is there, but in a space as heavily litigated as migration decision-making, of course, we do not want to open up any gaps in our framework. The
passage, to put it in the positive rather than the negative, the passage of this legislation reduces the risk that a legal challenge to the validity of these restrictions would be successful.
Correct.
Thank you. Okay, moving on to some factual matters. Since the YBFZ decision invalidated the previous restrictions on NZYQ-affected detainees, how many have had electronic monitoring conditions reimposed via the new regulation?
Senator, 10 people have had either EMD, curfew or both reimposed.
So 10 have had electronic monitoring or a curfew or both?
That's correct, Senator. So less than 5 of those 10 have both. The rest have just electronic monitoring.
Can you break it down for me? Like, how many only have electronic monitoring? And I'll ask follow-up questions.
Senator, because we're talking about such small numbers,
yes.
Again, so it's less
Give
than 5.
Give me as much detail as you can.
Both. So less than 5 people have both electronic monitoring and curfew?
No, that wasn't my question. I'll come to that category later. I'm starting with just electronic monitoring. So how many just have electronic monitoring?
So it's the balance of that. Less than 5 out of the 10.
Okay, so less than 5 have electronic monitoring only. Good.
No, sorry, have both.
I'm not asking about both. Please don't answer questions I'm not asking. I'll come to that in a moment. I'm going to work through this sequentially. How many are subject to only electronic monitoring?
So, Senator, the reason Mr Thomas is answering you in the way he is if he gives you that definitive number, then he is also answering the question about what the number less than 5 is.
Okay, I understand the restrictions placed on you. Just provide what you can provide. And I will ask you these questions sequentially, and you tell me what you can tell me. So, how many are subject to electronic monitoring only?
So, of the 10, less than the full 10.
This is very confusing. Okay, let's start the other way around. So, there are 10 who are subject to both electronic monitoring and curfews.
No, so there are 10 that have one or both of electronic monitoring or curfew in total.
Right.
So 10 people have the additional.
So how many have curfews only?
So that's that less than 10 number of the total, because there's less than 5 of those.
I understand. Normally you're willing to give me numbers above 5.
It's because there's only 2 numbers in that breakdown of 10. So if I give you the...
If you tell me that 7 are subject to a curfew, then I'll know that 3 are subject to electronic monitoring. Okay.
Sorry, I should have explained that better at the start.
Sure. Okay. All right. So there are 10 people subject to restrictions of any kind, of any of these 2 restrictions in the community now.
Correct.
How many were subject to restrictions before the YBFZ decision was handed down?
So there were 162 at the time of the YBF decision that had, again, either electronic monitoring, curfew or both.
How long ago was the YBFZ decision? Remind me.
It was the 6th of November, Senator.
Right. And so in the 3 weeks since then, after the reg was issued to remedy the court's decision, only 10 of those 162 have had some restriction reimposed on them?
So far since the ruling, we've assessed 48 of those cases.
Yep.
And of those 48, 10 have had conditions reimposed. We are working through the remainder of the cohort. Given the nature of the new test and its additional complexity, it has taken some time to take the cohort through to the delegate to make that assessment and decision.
So you've only been able to consider 48 of the 162. You haven't even got on to the other, 104?
It's an active process, Senator. We're working through
114, I think it would be, actually. 114. Right. I suspect I know the answer to this question, and it's going to be something less than 5, but let's see how we go. How many of the 12 murderers are subject to one of those conditions?
Senator, I don't have that particular breakdown with me.
Yeah.
Just with the time we've had, that's the breakdown I've been able to pull together.
Yeah. I'm sure the Minister would have asked you that question.
He hasn't, Senator.
The Minister is not interested how many of the former murderers...
I have the breakdown with the previous conditions, but with the new group, the 10, I haven't mapped that for today with the data against
Sure, but
the previous group.
Imagining myself in that role as a possibility in the future, I would have thought the first question the Minister would ask the department is, how many of the murderers have restrictions reimposed on them? Please prioritise the murderers. How many of them have restrictions reimposed? He hasn't asked you that question, or his office hasn't asked you that question.
Senator, we're working through the...
I know you're working through it, but that's not my question. My question is, has the Minister or the Minister's office asked you how many of the 12 murderers had restrictions reimposed? And the answer is?
No, Senator.
Right. Has the Minister asked you how many of the 66 sex offenders have had conditions reimposed?
No, Senator. We haven't had a discussion about the breakdown of that cohort yet, as we're still working through them.
I'm astonished that the Minister isn't curious about that. How many of the 97 people convicted of assault have had those conditions reimposed on them?
Senator, I don't have that breakdown with me.
No one here at the table has that breakdown?
No, Senator, if I could just give some context that the Minister knows that we are working through the cohort from the most serious risk to community safety, and so he has assured himself that we are prioritising those cases which carry the greatest risk.
Right, it's just not asking whether you've done anything about the murderers or sex offenders. So let's go to the 48. So 48 you've assessed, 10 have had the conditions reimposed. So that's 38 who have not had conditions reimposed.
Sorry, Senator, there's just one other. The Minister, in tasking the way the new test was imposed, we did advise him that it would be significantly more work-intensive to take each case through, and he did engage very clearly with us on the order of grouping of offence types he wanted us to work our way through, starting with the sex offenders and then those who may have had criminal offending relating to domestic violence, who may have had an AVO in the past. He's very actively engaged with us by cohort. I think what Mr Thomas is reflecting is that he is giving us the space to follow the legal process carefully and the new, much more intensive test to do it properly and get those decisions right.
We, of course,
in line with greatest risk to community
safety. We, of course,
safety.
all want you to get it right, but I'm not sure giving space is the right emphasis given the serious risk to public safety here. I mean, you've only assessed 48. There are 66 sex offenders, so you haven't even assessed all the sex offenders in the 3 weeks since the case is handed down.
So, Senator, I think it's been 2 weeks that the team has been working through this, and as both Mr Thomas and Ms Sharp have said, the test is significantly more stringent to respond to the High Court decision, and we must give weight to the test and work through each case as quickly as we can, but taking into account our legal requirements against that test.
Okay, so if you started with the sex offenders, you've assessed 48, 10 have restrictions. Does that mean 38 sex offenders don't have restrictions?
No, Senator, not all of the 48 are necessarily people with previous sex offending
Well,
history.
Ms Sharp just said that your advice was to start with the sex offenders.
We've prioritised those initially, as well as a few other cohorts.
Well, there are more sex offenders than the ones you've assessed, so you're either not following the Minister's advice and you've gone outside his direction to do the sex offenders first, or you have only done sex offenders.
It wasn't a straight list, it was top priorities, and we're working through those.
Okay, what can you tell me about the 38 who have no conditions, who you've assessed and now have no conditions imposed on them? Are any of them sex offenders?
Some of them would be, yes, Senator.
Are any of them child sex offenders?
I would say so, as they were one of the ones prioritised first.
Right, so we have child sex offenders in the community with no curfew and no electronic monitoring.
Senator, to be clear, they are still subject to the mandatory conditions on the visa.
Including not being able to go near schools and childcare
reporting.
centres, which is important, and I'm glad to hear that, but they don't now have electronic monitoring or curfew. If I remember correctly, one of the rationales for electronic monitoring was to help enforce those other mandatory conditions about going near schools and childcare centres. So how do we know these child sex offenders who have no electronic monitoring or a curfew are not breaching those conditions?
Senator, just to go back to the test again, each individual was assessed against the test to determine if they pose a substantial risk of seriously harming any part of the Australian community. That was the test for imposing those conditions. In terms of their compliance with the other mandatory conditions, there are other mechanisms in place through things like Operation Aegis to actively engage with and work with the cohort. Again, regular reporting, regular contact to understand.
Sure. Thank you, Mr. Thomas. As you know, this is a highly recidivist cohort. I vaguely recall last time I asked you for these statistics that of the 215 at the time who'd been released, 65 had been charged with state or territory criminal offences. This is a highly recidivist cohort. It includes people who've committed very serious crimes. I'm alarmed to know that there are child sex offenders out there who are not subject to electronic monitoring or a curfew right now.
So, Senator, clearly we have an obligation to apply the test that was regulated,
Of course.
And that test was developed in response to the High Court ruling. I think it's also been put on the record that in anticipation or in preparation for an adverse ruling, Ms Jeffrey has expanded the capacity within Operation Aegis by 66% so that we are able to increase significantly our monitoring of that cohort in the context of having a more stringent test.
What kind of monitoring?
I'm just going to share the call after this answer, but we will come back to these questions. So, sorry, continue.
Senator, that would include just more contact with the cohort. If we can't do it electronically, it would be face-to-face.
Okay.